Our last contributor in this section is Avvocato Delia Ferri. She graduated in law in the University of Verona in 2003. Subsequently, her doctoral thesis was in EU cultural law and policies, and she was awarded a national prize for that subject in 2008. She subsequently published a version of her doctorate, and that publication received a considerable acclaim. She has earned a diploma in EU law at the Central European University in Budapest. She has lectured in European Union law in the Jean Monnet Centre at the University of Trento. She is a visiting fellow in European law. She is a registered attorney at law on the Verona Bar. She works as a counsel for a law firm in Verona. Sure, she does everything. She is going to speak to us this afternoon in the context of the necessity for legislating at EU level, possibilities and challenges, precisely the issues that I was seeking to touch on a moment ago. So thank you very much indeed, Delia. Away you go.
Thank you very much for this presentation. And allow me to thank the organizers of this conference. I'm delighted to be with you today. It's a true honor for me to contribute to such an important event. And allow me to express my special thanks to Professor Jerquin and Aislinn Power. Well, my task today is to discuss with you the EU competencies to legislate on genetic discrimination and on the use of genetic data. It's an hard task indeed because, it's a very broad issue. But I will try to give you a big picture. So allow me to apologize from the very beginning because I'm not going into detail. And allow me also to apologize because my English is not so good as it should, but I hope you can understand me. Well, I want to open my speech with a few preliminary remarks and saying that we have a body of international soft law documents relating to genetic discrimination. This morning, Jan Joly mentioned the UNESCO Declaration on Human Genome, and Professor Roskam before mentioned the recommendations of the Council of Europe. We have also a binding convention, the Oviedo Convention. And we have a lot of national legislation, at least in Europe. Jan Joly this morning mentioned these laws. However, at the EU level to date, there is no regulation specifically dealing with the data, genetic data, the protection of genetic data, and at present there is no specific regulation on genetic discrimination. This does not mean that the EU has no competence to legislate, and this does not mean that the EU has no interest in legislating in this field. Professor Roskam illustrated before the advantages of an EU regulation of European standards and explained very well why we should have a European regulation on that. And so I'm not going to treat this issue because all the reasons were explained before. Today, I want just to tell you that the EU has shown great concerns regarding the use of biotechnology in general. In 1989, the European Parliament passed a resolution, so a soft law document on legal problems of genetic engineering. And in 1996, another resolution was passed, another soft law document. But this soft law document shows how the EU is interested in passing a binding instrument. In 2004, a report was requested by the Commission, a report on genetic data, on ethical, legal, social aspect of genetic testing. And last but not least, in 2011, in October 2011, the Court of Justice passed a decision on the patentability of human embryos. I'm sorry, I don't know what is going to happen. They have the slide on paper. It's a thing.
Okay, it's just warming up again, so it might just take a few minutes. Okay, sorry about that.
But I can continue to speak. It's not if the. It's just. Well, the document and the soft law, the decision of the European Court of Justice, show that the EU has interest to legislate. Well, today I will try to address 3 main points. First of all, I would like to deal with the EU competence to legislate. 30 seconds.
Oh, yeah, okay, great.
The EU competence to legislate. I will consider the EU constitutional framework, and I deal with constitutional framework because the European Court of Justice dealt with the treaties as the supreme law of the land, as a constitutional charter of the European Union. So when we deal with a constitutional framework, we deal with the treaties, and today integrated by the Charter of Fundamental Rights, which is binding now and which has the same force of the treaty. Secondly, I will focus on EU secondary law, in particular on the directives, on the directive on data protection, and also on the directive on non-discrimination. Finally, I will use the preceding analysis to provide some concluding remarks on the opportunity and the feasibility to have an EU regulation. Regarding and I will try to also to analyze, the possibility to adopt a privacy approach and a non-discrimination approach, and to combine this approach at the EU level. Well, regarding the EU competence to legislate, first of all, we have to, it's worth noting that the EU has an exclusive competence in the field of competition, which is a wide field because there are a lot of issues that are falling in the field of competition. In addition, the EU has a shared competence in the field of employment, but this shared competence is very wide, it's very extensive, covering freedom of movement, equal treatment, but also working conditions, equal pay, part-time working. In addition, again, the EU has competence to legislate on the insurance field within the other competence of the freedom to provide services. The EU has also supporting competence in the field of health. Supporting competence is a very limited competence, but we have also to remind that the EU has a shared competence provided for in Article 6 of the Treaty on the Functioning of the European Union on common safety concerns in public health matters. So you see, there are, I would say, fuzzy boundaries among these fields of competencies. And we must be very careful when we deal with competencies, because we are not dealing about something that is fixed. We are dealing about something that is moving, is living. We have a lot of case law and the ECJ decision on competencies, on the meaning, for instance, of employment within the EU constitutional framework, as well as discrimination, as we will see. The EU has a sound competence to rule on the protection of genetic data. And this competence is provided for in Article 16 of the Treaty on the Functioning of the European Union. Everyone has the right to the protection of personal data, and the European Parliament and the Council, acting in accordance with the ordinary legislative procedure, shall lay down the rules relating to the protection of individuals in this field. In addition, the right to privacy is provided for in the European Charter of Fundamental Rights. Professor Roskam before quoted it. The EU has also a solid cross-cutting competence in the field of non-discrimination. And, well, the principle of non-discrimination is firmly embedded in the treaty. There are several articles mentioning the principle of non-discrimination and equality. Article 2, Article 3 regarding the aims of the European Union, and even not, it's not a direct reference, but an indirect reference, we can quote also Article 6. And then Article 10. Article 10 contains a non-discrimination cross-cutting clause. This clause states that in defining and implementing its policies and activities, the Union shall aim to combat discrimination based on sex, racial or ethnic origin, religion or belief, disability, age, or sexual orientation. Genetic features is not mentioned as a ground of discrimination in this clause, in this cross-cutting clause, but disability is mentioned. And this is a very, very important clause because in my opinion, it's really widens the competence of the EU in a certain way. Then Article 19 is the most important provision in this field because it's really the main legal basis for the EU Act on Non-Discrimination. And Article 19 of the Treaty of the Functioning of the European Union, former Article 13, does not mention, as Article 10, genetic features, but as a ground of discrimination. But it mentions disability as a ground of discrimination. We will see why later on why I'm insisting on this ground, disability. Last but not least, we have Article 21 of the EU Charter of Fundamental Rights that was also mentioned by Professor Roskam. And by contrast, genetic features is a ground included in this article. Well, Article 21, there is a problem with Article 21 because Article 21 cannot be a legal base, an autonomous legal base. So it means that the EU cannot, does not have any power to legislate on the basis of this article because the EU cannot exceed the competencies that are provided for in the treaty. And in particular, the explanation of the charter, which was published in the official journal of the European Union in 2007 clarify that the EU cannot ban discrimination on all the grounds provided for in Article 21, because the main provision we have to refer to is Article 19 of the treaty. It was written like that in 2007, but now the Charter is binding. And the respect of the Charter provision is a legal requirement and is a condition of lawfulness of EU acts. There are two very, very important cases on this issue. They are not related to disability or genetic discrimination, but they are connected to the value of the Charter, and are Marcus Schecke case and the Testachat case, in which the court examined the validity of EU acts in light of the EU Charter on Fundamental Rights. In addition, the Commission in 2010 published a communication, so a soft law document, a non-binding document, in which it's clearly written that in the Charter must be taken into account throughout all the policy cycle. So the Charter is a point of reference for new legislation. It's not a legal base, but it's a point of reference and an assessment of the compatibility of legislation with the Charter must be carried out before passing a legislation at the EU level. Well, what can we infer from these provisions? And what can we infer from Article 19, Article 21, from the documents I've quoted? Well, this is my opinion, and well, I think that Article 19 could be a suitable legal base for a legislation on genetic discrimination. Well, this is so because Article 19 must be interpreted in light of the constitutional framework of all the provisions contained in the treaty, and must be interpreted in light of Article 21 of the Charter of Fundamental Rights. It could be so also interpreting the term disability in an extensive manner. So considering disability, the ground of disability, covering genetic discrimination. Such an extensive interpretation, it's a little bit tricky, because the Court of Justice up to now has adopted a very narrow interpretation of the ground of disability in particular, of all the grounds in general, but of the ground of disability in particular. The Court of Justice, there are very few cases on disability, but the most important case, two landmark decisions, are Chakan-Navas and Coleman. In Coleman case, the Court of Justice admitted discrimination by association, but the Court of Justice interpreted Directive 2078 in that case, and interpreted the grounds mentioned in the directive that are the same grounds contained, of course, in the legal base, former Article 13, now Article 19. And the Court of Justice said that the directive and the principle of non-discrimination can be interpreted extensively ratione persone, but not extensively regarding the grounds. So the term of disability cannot be interpreted in an extensive manner. And the Court of Justice in Sonia Chakan-Navas' case precised this this notion of narrow interpretation, because in that decision, the court adopted a very restrictive notion of disability based on the old-fashioned medical model. This decision is very, very criticized by legal scholars, and probably there will be an overruling, a reversal by the court in the future. But nonetheless, we have to take it into account because the court adopted a very restrictive notion. So we do not have to expect an extensive interpretation of the ground of disability coming easily. Nonetheless, I think that such a wider interpretation should be in line with Article 21, with the constitutional framework, and I think that Article 19 could be really a suitable legal base. And such a wide interpretation could be also in line with the other rights provided for in the Charter, the right of dignity, and the rights of integrity of person. Professor Roskam mentioned it. Well, another issue that we have to consider is that the EU has signed and ratified the UNCRPD, the UN Convention on the Rights of Persons with Disability. And this is very significant in this context because, as we know, the UNCRPD is now part of the EU legal framework, is literally EU law. I'm not going into detail, and I'm not going to explain the relevance of mixed agreements because it's a very, very, very tricky issue. And it's an hot topic in legal doctrine. But I just want to tell you that the UNCRPD, as all mixed agreements, has a position in the sources of law hierarchy, which is in the middle between the treaty and secondary law. So is higher law in respect to directives, regulation, and secondary law in general. So this is very important because the EU has not only an international obligation to implement the convention, but also from the point of view of the sources of law, the UNCRPD is an internal source of law within the EU legal framework and must be taken into account. I don't think it can be an autonomous legal base. We cannot think to a EU law based just on the convention. But because, of course, the EU ratified the convention within the field of its own competences. There is a declaration of competence annexed to the decision. But anyway, it's important to say that from the formal point of view, the convention must be used to interpret and must be combined with the treaty provision, must be used also to interpret the provision. From a substantive point of view, we have also to consider that Article 1, Para 2 of the UNCRPD state that persons with disability include those who have long-term physical, mental, intellectual, or sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. This is not a definition. This is just, I would say, a bare minimum. And so an EU legislation could include in disability, in persons with disabilities, or also persons with have genetic differences, I would say that. In addition, the principle of equality and non-discrimination is firmly embedded in the Convention. And this principle must be interpreted very, very widely to cover not only persons with disabilities, but also the ban of discrimination on the basis of assumed or future disability. And this interpretation of Article 2 and Article 5 of the Convention must be taken into account in order to, when we think to EU, another EU directive on non-discrimination. So, to conclude this part, we can say that the EU has competence to legislate both on the use of genetic data as well and on genetic discrimination, even if the competence on genetic discrimination is a little bit contested. It's not so, I would say it's not so sure, can be discussed. Let's now pass to the second part of my intervention on EU legislation currently into force. I will be very brief, and I will just mention Directive 95/46 on the protection of genetic data. It's the main legal test. It's not the only one, but it's the main legal test, and it mentions the fact that data must be collected with proportionality. There is the need of the consent of the person to which the data belong, the data belong. And this directive does not mention genetic data, but mentions health data. So we could think that interpreting in an extensive way health data, we can think that this covers also genetic data. In addition, the data must be accurate and not excessive in relation to the purposes for which they are collected, and they cannot be kept for an unlimited time. Well, this directive is going to be modified. There is a statement of the Commission of there is a communication of the Commission of 2010, but there is also a new statement of July 2011 in which the Commission stated very clearly that a new legislation on the protection of genetic data is needed at the European level, in particular in order to include and to protect the use of genetic data. Also, the European Parliament on 6 July 2011 published a report on this issue, and the Parliament, of course, agreed on the need of a new legislation. Well, the non-discrimination directives are the racial directive, the 2043, and the so-called framework employment directive, 2078. Of course, the most relevant for our purposes is the 2078 directive. And this directive implements the principle of equal treatment in the area of employment, but prohibits discrimination on various grounds, including disability. And as I said before, genetic discrimination is not covered by this piece of legislation, but interpreting in an extensive way disability, we could think to the fact that genetic discrimination could be covered by this directive. Well, I don't want to repeat myself and the consideration I have already made before on the Coleman and Cioconna cases, but we have not to expect such a very extensive interpretation too easily. So that's why it's important to see if a new legislation is feasible. Well, another thing must be considered, that the Directive 2078 has a very narrow scope. It prohibits discrimination only in the fields of employment and related fields, so vocational training, basically, but not in all the other fields. So, for instance, the insurance field is excluded. That's why we need also to think about a new regulation on this, a new legislation on this issue. Well, the Directive 2078 should be complemented by a new directive. There is a proposal for a new non-discrimination directive. This proposal was released by the European Commission in 2008 and is under discussion. Probably in 2012 we will have this new directive. But it's not sure because there are a lot of discussion on the material scope of the directive and also on the substantive provisions inside this new proposal. Well, indeed, the material scope of the directive is analogous to the one of the racial directive. Nonetheless, many member states are contesting this wide scope. They are saying that the EU has not this competence to pass such a broad directive. And that's why there are difficulties on this specific provision on the material scope. Another shortcoming of this proposal, which has been highlighted by legal scholars, is that this directive does not attempt to develop EU law. Just tries to widen the scope, the material scope of the previous employment directive. And this is true because we don't see any real and true novelty in the text of the proposal. Nonetheless, we have also to underline the positive issues of this proposal. First of all, the proposal mentions the conventions, relies on the UNCRPD for what we think about disability. So disability, the notion of disability is not defined by the proposal, but the proposal relies to the convention. Secondly, this proposal does not widen the definition of discrimination, but consider discrimination also the denial of reasonable accommodation. And this is very important because this is really in line with the convention. And finally, this directive is trying to move forward to develop the provisions on discrimination on the ground of disability. Of course, this is just a proposal, and we cannot say anything really definitive because we really have to see what is going to happen. The problem with this proposal is that, of course, it does not contain any reference to genetic discrimination. Secondly, the area outside employment, as I said before, does not are going to be restricted because some member states do not agree with such a wide scope. We will see. And in addition, regarding our purposes, we have to mention a restriction. Article 2.7 authorizes proportionate differences in treatment in financial services, including the insurance services, provided that age or disability is a key factor in the assessment of risk based on relevant and accurate statistical data. This is very relevant for us because, well, we are dealing with genetic discrimination, and this exception may endanger the protection of EU citizens. This provision is not new. A similar provision is contained in the Gender Service Directive, and this provision has been recently interpreted very narrowly by the Court of Justice in the Testa Shah case. But in any case, such provision is really a tricky issue for genetic discrimination. I'm going to conclude, and I want just to say that these are tentative conclusions. Any definite answer can be given today, I think, because also we have to consider that the EU legal framework is an ongoing framework. It is developing every day. And, well, what can we say? I think that a directive, a regulation on the protection of, on the use, better, of genetic data is forthcoming. We saw the Commission statement and the Parliament statement, and so it's forthcoming. The privacy approach can be adopted, easily adopted by the EU, and would be adopted. Regarding the non-discrimination approach, which should be combined with the privacy one, there are, of course, some problems because we saw that Article 19 does not contain genetic features as a ground of discrimination, and because all the reasons I have tried to explain today. In addition, we should also discuss whether the EU should pass a new non-discrimination directive or should amend the existing directives, both the 2078 directive and the proposal. Well, to amend existing directives, as well as the proposal, should be probably easier from the political point of view. But, are we sure that it would be sufficient? Probably not, because we have to define what is genetic discrimination, what are genetic data, what we intend for genetic data, to be more precise. And this could be better done with a new horizontal directive. This could be probably a better solution. A new horizontal directive could take more time to be adopted, maybe not 13 years like the GINA, but a lot of years. And there could be problems for the material scope, for other many issues related, the relation with other grounds, the multiple discrimination, and these kind of problems. But okay, we will see what is going to happen. I have not an answer on this issue. I think that an horizontal directive could be envisaged at a European level. I want to thank you very much for your attention, and of course, if you have questions, I will be happy to answer.